Yeah, please start. Introduce yourself and then start.
Yeah. Hello, everyone. I'm Srinivas Kamat. I'm into third semester of three-year LLB, and I have chosen the topic of study of bankruptcy laws in India. Yeah. So I will introduce the topic in the beginning, kind of introduction. So the bankruptcy is a legal defined process that provides certain protections and relief to the individuals, or family, or companies who are unable to pay off their debts. Uh, Bankruptcy is kind of a legal declaration of insolvency. So now this insolvency and bankruptcy are mentioned together, or often used interchangeably, but they are not the same, and have two different meanings, and these are two different process overall as per the law established. Uh, there are insolvency is a financial condition of an individual or a company or family which has lost the capability to pay off their debts to the creditors. When any individual or entity is not able to pay back the debts to the creditors on time, and does not have financial viability, I mean, does not have any means of finance or cash inflow for discharging oneself from the liability, then the individual or the entity is called as insolvent. Yeah. So this is little back introduction on the topic here. Now I go back little back in the time to give the background. Actually, India did not had any clear policy or comprehensive law for corporate bankruptcy. So this was pending from a long time. There were multiple legislations and acts which were governing this process, but nothing concrete was available. For example, we had the Sikh Industrial Companies Act 1985, and the Recovery of Debts Due to Banks and Financial Institutions Act 1993, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act 2002, and Companies Act 2013. So these were some of the major acts which were governing, and along with some other acts and maybe notifications from Ministry of Industries, etc. The first Indian Insolvency Act was promulgated in 1948 during British era. So this was in line with the British Act, which was contemporary. They were basically Individual Insolvency Act, and it was passed officially sometime in 1907. And this was applicable only as a provincial act, and they also passed another act for presidency towns in 1909. So this was kind of a background on what we had, or what was before this bankruptcy act was enacted by the parliament. So Ministry of Finance created a bankruptcy legislative reforms committee on 22nd August 2014. This committee was headed by T.K. Vishwanathan, and their main task was to draft a new bankruptcy law. The committee submitted its report, which was a draft bill, on November 2015. Later, after public comments and kind of a review and etc., it was introduced in the 16th Lok Sabha by then Finance Minister Mr. Arun Jaitley as the Insolvency and Bankruptcy Code 2015 on 23rd December 2015. A joint parliamentary committee, JPC, on the Insolvency and Bankruptcy Code 2015 was set up, and the bill was referred for its detailed analysis. JPC submitted its report, which included a new draft bill, and sometime in April 2016, it was passed. It was presented in Lok Sabha, and on 5th May 2016, the Lok Sabha passed it. Subsequently, 11th May 2016, Rajya Sabha passed it. So this was later notified by the President of India in Gazette of India during May 2016, 28th May 2016. So this was the path, or how IBC was enacted, yeah, in India. Key features of this Insolvency and Bankruptcy Code 2016 are applicable to both corporate and non-corporate persons. So earlier, as I mentioned, the British law was mainly applicable for the individuals. Yeah. So this was a comprehensive act which was applicable for both corporate and non-corporate entities. So this allowed creditors, whether secured or unsecured. So if you may know, there are two types of loans given to the corporate entities, mainly like secured and unsecured. So this covered both the creditors, a financial institution or operational financial institution, domestic or international, to initiate a resolution process, thereby aiming the early detection of fraud. Establishes time-bound moratorium and on acceleration and enforcement of debts against the company. The resolution professionals can replace the existing management during the insolvency proceedings. Provides for time-bound viability assessment mechanisms, liquidation processes, and distribution of calls. It also provides for promoters for asset diversion leading up to liquidation. The provision of the code overrides all the previous acts, mainly the SRFAESI Act 2002. An inability to pay debt will no more be ground for winding up under the Companies Act. So this overrides some of the earlier provisions which I mentioned, like various acts were having. So these acts will override most of the provisions, or kind of a free hand given to the companies by declaring themselves bankrupt and wind up the operation. So this is no more a possible thing. Voluntary liquidation shall be subject to provisions of the code. So the overall process is called as insolvency resolution. So the code outlines separate insolvency resolution process for individuals, companies, and partnership firms. The process may be initiated by either the debtor or the creditors. A maximum time limit for completion of the insolvency resolution process has been set for corporates and individuals. So for companies, the process is for 180 days, which may extend it by another 90 days if a majority of the creditors agree. For startups and partnership firms and small companies and other small companies, which are basically turnover less than 1 crore, this is again can be updated by Ministry of Finance on notifications time to time. So as on today, I take it as 1 crore from what I downloaded in the BEAR Act. So the resolution process for these companies is 90 days, and which can be extended by 45 days if again the majority of the creditors agree. In 2019, again the government realized there needs some updates. So the maximum or the upper limit of entire legal process to complete was like set to 330 days. I do not have exact information. I try to recollect, but it seems some of these extensions, like 180 days and then 90 days, 90 days. So these were happening way too much, and that's when Parliament felt, okay, we should put a time limit or ceiling on this extension. So that was set to 330 days. And next is the insolvency regulator. So Act establishes the Insolvency and Bankruptcy Board of India to oversee the entire insolvency proceedings in the country and regulate the entities registered under it. The board will have 10 members, including representatives from Ministry of Finance, Ministry of Law, and Reserve Bank of India. Insolvency professionals. So these are also key persons who will actually oversee the entire process, and they will manage. They will be managed by the entire process will be managed by the licensed professionals. So these professionals will also have control of the assets of the debtor during the insolvency process. So this again says the previously which I mentioned, the insolvency professionals will replace the management or board of directors or whatsoever. So they will be in control of all the assets and financial assets of that particular company or firm which is going into insolvency process. So the next is bankruptcy and insolvency adjudicator. The code proposes two separate tribunals to oversee the process of insolvency resolutions. That's again individuals and the companies. The National Company Law Tribunal, NCLT, often it is referred as NCLT, it's for companies and limited liability partnership firms. Whereas the Debt Recovery Tribunal, DRT, is for individuals and partnerships at individual level. The applicability of the Insolvency and Bankruptcy Code 2016 is all kinds of corporate enterprises, limited liability partnerships, partnership firms, and individuals. So the scope is insolvency, liquidation, voluntary liquidation. That's again sometimes legally termed as solvent insolvency, and bankruptcy. So I'll come to the structure of the code here. The structure in entirely, the code has 255 sections, which are divided into 5 main parts as given below. Part 1 is preliminary, basically contains the definitions and who is who and etc. Part 2 is insolvency resolution and liquidation for corporates. Part 3 contains insolvency resolution and bankruptcy for individuals and partnership firms. Part 4 is regulation of insolvency professionals, agencies, and information of utilities. Part 5 is miscellaneous parts, where are some amendments in other statutes or codes is mentioned there. So apart from these 5 parts, code has also schedules. So far it has 11 schedules, which provides for amendments to be carried out in the other codes or statutes. So that's on one part. Now I come to the insolvency resolution and liquidation for corporate persons. So the corporate applicant or corporate person means a corporate debtor, a member or partner of the corporate debtor who is authorized to make an application for the corporate insolvency resolution. An individual who is in charge of managing the operations and resources of the corporate debtor, a person who has control and supervision over the financial affairs of the corporate debtor. So these are the people who can initiate or who are responsible for initiating the insolvency process. So how it is done? So they will submit an application for insolvency proceedings to the adjudicating authority, which is again here National Companies Law Tribunal. The application may be filed by creditors or corporate debtor himself. So section 7 and 9 oversees filing by creditors. Section 10 oversees filing by the corporate debtor itself. The maximum time allowed to consider the application is 14 days. So that means once the application is filed in front of NCLT, so they have to decide on admitting it or rejecting it within 14 days. So there's a time limit set. If the application is allowed, then the adjudicating authority, that is NCLT, declares a moratorium on the insolvency commencement date. The NCLT shall order declaration of moratorium for prohibiting all the following, namely the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, order in any court of law, tribunal, arbitration panel, or other authorities. Transferring, encumbering, alienating, or disposing by the corporate debtor of any of its assets or legal rights or beneficial interests, etc. Any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of the property, including any action under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act 2002. So this again a recovery of any property by an owner or lessor, which whereas such property is occupied by or in possession of the corporate debtor. The next thing is on the public announcement of the insolvency process. So this corporate insolvency resolution process should be publicly announced with the name and address of the corporate debtor, name and authority where the corporate debtor is registered, last date for submissions if any public or anybody who is involved or in business with this corporate can submit for claims, yeah, which was not known to the existing creditors, etc. So these will all be taken care, and these submissions are again, or declarations are again governed by section 7, 9, and 10. So at the next stage is appointment of interim resolution professional, uh, where the application for corporate insolvency resolution process is made by the creditors or the corporate debtor as applicable. They can even mention if there is any resolution professional from their end. But there should be no enquiry or cases pending against the person whom they are willing to appoint as resolution professional or interim resolution professional. Otherwise, the adjudicating authority, that is NCLT, can appoint an IRP or RP, that is resolution professional, under section 80. So I'll come back a little later on the next process once the IRP is appointed, because more or less the process is same later on. So I will say what is the process in case of individuals and the partnership firms. So here also more or less it is the same, that debtor can apply either personally or through the resolution professional for a fresh start under qualifying debts and adjudicating authority if the gross annual income of the debtor does not exceed 60,000 rupees. This is again subject to change based on the notifications from Ministry of Finance or Corporate Affairs. As on today, the Bear Act says it is 60,000 rupees. The aggregate value of the assets and the debtor should not exceed 20,000 rupees. The aggregate value of the qualifying debts does not exceed 35,000 rupees. And previously, there should not be any undischarged bankruptcy announced. The individual or the partnership firms does not own a dwelling unit like a small office or so owned by them. And the adjudicating authority here means debt recovery tribunal constituted under section 3 of IBC. Yeah. Okay. So once the resolution professional or the interim resolution professional is appointed, the process for corporate insolvency resolution is as follows. In short, it is often referred as CIRP, Corporate Insolvency Resolution Process, wherein admission of the application and appointment of the interim resolution officer is the first thing, and then collation of claims and constitution of committee of creditors by the interim resolution professional or resolution professional. This happens in case of there are multiple creditors to a company or an individual. The next step is appointment of resolution professional in a creditors meeting to be held within 7 days of constitution of committee of creditors. That is, I mean, the same person who was appointed as interim resolution professional can continue if the creditors agree to it. Otherwise, a new person will be chosen or appointed as a resolution professional. So that's what this stage means here. So the resolution professional, once appointed, he has to prepare the information of memorandum, and resolution applicant to prepare and submit the resolution plan, like revival plan, etc. The resolution professional will examine this and further submits it for the committee of creditors that is constituted by the resolution professional. Again, if the resolution plan is approved by the committee, then they can go ahead and kind of a fresh start, or new plans of business will be made available, and they will try to run this business. If the resolution plan is rejected by the committee, then it will go for insolvency. So that includes NCLT coming into picture and oversee the entire liquidation process, and the time frame and the act related time frames will be monitored by NCLT along with the resolution professional here. So that's all from me.
Yeah, any questions? Another question, Sidya, insolvency ಬಗ್ಗೆ? Yes, Dinesh.
No questions.
Okay. So, okay, thank you so much. It was really very nice, in-depth.